We are here today on 3 cases for Mr. Tanner.
Judge, this is bond revocation, I believe.
He has a new case, Judge, that is
Well,
20
hang on. Okay, but on this case, Ms. Gillette, he has a jury trial set, it looks like already for August 22nd and a pretrial at August 17th, correct?
Yes. So Mr. Tanner's on an ankle monitor, and that's something that you put on him because this is a felony domestic battery, third or subsequent, along with disorderly conduct. And he was back over at the victim's house and picked up the second case number 23 CR 48, because he was going back over to where his victim was. In the meantime, he's had multiple reports, and I even forgot one in the motion of failures to comply with his GPS monitor. And so we just got another report of dead batteries on the GPS. That was a significant list of things he has not been doing. So we put them all in a motion. And so he is currently not complying with his GPS. So we asked for a warrant, filed a motion, and the judge approved a warrant for failure to comply with his bond conditions, not keeping his GPS on. He's disappearing for hours up to days at a time.
Okay. Well, let's start with the first appearance then on the newest of the 3 cases. In 2023 CR 142, Mr. Tanner, you're accused of giving a worthless check. That is a charge that alleges that on or about the 13th day of May in 2023 in Greenwood County, Kansas, you issued a worthless check by making, drawing, issuing, or delivering a check, order, and draft on a bank, credit union, savings and loan association, or depository for the payment of money or its equivalent with the intent to defraud, and knowing at the time of the making, drawing, issuing, or delivering of such writing that the maker or drawer had no deposits or credits with the drawee for the payment of such check, order, or draft in full upon its presentation, specifically delivering check number drawn on the home bank and trust account to G&W Foods in the amount of $308.75. As charged, this would be a Class A non-person misdemeanor. And that means that if you were convicted, the maximum possible penalties could be up to a year in the county jail and a fine up to $2,500. Do you have any questions, Mr. Tanner, about the charge or the possible penalty?
I don't have any questions, Your Honor. I have the money to pay that. Honestly, just forgot about it. I just finished paying off my bank account for the negative fees for that.
All right. Well, who's your attorney in the other 2 cases?
Ambrose.
I don't know if he will take this misdemeanor or not. Do you want an attorney to represent you in this count, sir?
I assume yes, ma'am.
All right. Your circumstances financially have not changed since Ambrose was appointed?
No, ma'am.
Okay. So I'm going to appoint Attorney Shannon Cooper. You do need to be back here before me by Zoom, August 8th at 3:30. Now then, you are set in pre-trial and jury trial on the other cases. You've indicated your attorney is Christopher Ambrose, and I have confirmed that. It looks like your reasoning for being here today is not because you failed to appear, but because the state is alleging that you have been violating the conditions of your bond, which require you to stay away from the alleged victim. The allegations are that you continue to have a dead battery on your GPS monitor. And it is required, Mr. Tanner, that you keep that battery charged at all times.
Yes, Judge Crum has the felony case.
Okay. All right, so Mr. Tanner, why can't you keep that battery charged?
My charger, so I did get in trouble back in May.
Yes.
And I did do a way better job. I contacted Green Feather. My charger wasn't working.
Mhm.
I contacted them when it was blinking red, and then it did die. And after a day or two, I actually took my knife and cut out the bad spot in the charger and spliced it together because they said I could buy it for $30 and fixed it. And that's why I came back online. I needed a good charger, and I didn't hear back from Green Feather. And that's why I was able to get my ankle monitor to even charge in the first place.
Well, that monitor is on to satisfy the court's concerns. You didn't have any authority to contact Green Feather and cut your bracelet off.
No, ma'am. I didn't cut my bracelet off. The charger that charges it wasn't working. It had a bad spot in the charger.
Well, do you understand that the monitor is what allows you to be free and out of jail?
Yes, ma'am. That's why I wanted to fix my charger.
What is the state's recommendation on this issue of bond, Ms. Gillette?
Well, Judge, I forgot to list the February violation where he didn't keep it on and charged in February. But this is not a one-time thing. This is multiple times. And so he had 9 dead batteries in May over the course from May 1st to May 18th. Some of those for over a day. And then he had a second report for June 23rd and 24th. And so he was off for more than 24 hours then. Then we received another report from June 29th from 7 a.m. till 2:34 p.m. And then there was also one back when he first got it. So this isn't a one-time thing. This isn't a one-time charger issue. This is a failure of the defendant to keep his bracelet on. These are serious allegations. It's felony domestic battery. So I would like him to have to be before Judge Crum. Judge Crum had admonished him. Mr. Ambrose had admonished him. I had brought it up on numerous court hearings, and Judge Crum had told him no further issues with the ankle monitor will be tolerated at his hearing May 25th. Since then, he had more issues. So Frank,
Okay,
I will
go
need
ahead.
custody till he sees Judge Crum, and his next hearing date is August 17th.
I would like to have him see Judge Crum on the bond revocation before that date, if that's possible. As I said, when I approved that bond, I didn't realize the case had already gone on to Judge Crum, or I would have asked Judge Crum to address whether the warrant should issue or not. So I do want Judge Crum to look at the matter. And so Missy, I'm going to need a date for him to get in front of Judge Crum as soon as possible for a bond revocation hearing that his attorney can attend with him. Is there any way we can do that much, much sooner, like maybe in the next, 24, 48 hours, something like that?
I'll have to message his AA because I don't have control of their calendar.
All right.
But I can do that and CC his attorney in it.
That would be good, that I signed that, not really realizing the case had gone on to Judge Crum, and I'd like for Judge Crum to look at that as soon as possible.
We have court next week with Judge Crum as well. So
On this case?
not specifically on this case, but Judge Crum's days for Greenwood and Elk are next week.
Okay. Well, for right now, Mr. Tanner, I've given you the dates, but in the meantime, my assistant Missy is going to try to get you a bond hearing in front of Judge Crum, so he can hear the allegations, your attorney can respond to them, and see whether or not Judge Crum thinks you should stay incarcerated or if the bond should be reinstated with new conditions or whatever the situation might be. Hello, sir. What is your name, please? They're at the jail.
Wayne Everly.
Wayne Everly. All right, Mr. Everly will be on the record in your case, number 2023 CR 156, State of Kansas versus Wayne E. Everly, in custody and pro se. Sir, you are here for first appearance on a number of charges, and I'll go over those with you, as well as the possible penalties and rights relating thereto. In count one, sir, you are charged with aggravated battery. It is alleged in this count that on or about July 9th, 2023 in Greenwood County, Kansas, you did then and there, contrary to the statutes of the state of Kansas, recklessly cause bodily harm to another person, to wit, with a deadly weapon, to wit, a lawnmower, in a manner whereby great bodily harm, disfigurement, or death could be inflicted. As charged, sir, this is a level 8 person felony, which means depending on your criminal history, if any, you were to be convicted with this charge. Your penalties could be anywhere from 7 months to 23 months in the Kansas Department of Corrections, commonly called prison, and you could be ordered to pay a fine up to $100,000. In count two, you are charged with another count of aggravated battery that on or about July 9th, 2023 in Greenwood County, Kansas. You did then and there, contrary to the statutes of the state of Kansas, recklessly cause bodily harm to another person, to wit, with a deadly weapon, to wit, a lawnmower, in a manner whereby great bodily harm, disfigurement, or death could be inflicted. This charge means that if convicted, you could serve another 7 months to 23 months in prison and pay another fine up to $100,000. In count three, you're accused of that on that same day of July 9th, unlawfully and knowingly place another person, to wit, in reasonable apprehension of immediate bodily harm with a deadly weapon, to wit, a lawnmower. This is charged as a level 7 person felony, which means in addition to the first two counts, if convicted, you could serve another 11 months to 34 months, and you could pay a fine up to $100,000. In count four, you're accused of another count of aggravated assault, placing in reasonable apprehension or reasonable apprehension of immediate bodily harm with a deadly weapon, to wit, a lawnmower. This is also a level 7 person felony with 11 to 34 months possible sentence and another fine of up to $100,000. In count five, you're accused of criminal damage to property on that same date by means other than fire explosion. It is alleged that you damaged, destroyed, defaced, or substantially impaired the use of property, to wit, a mailbox and mount in which another has an interest, to wit, without the consent of such person, and the damage done was less than $100,000, making this a Class B non-person misdemeanor. If convicted, you wouldn't go to prison on this one. You would remain in the county jail there where you are now for up to 6 months and pay a fine up to $1,000. Sir, do you have any questions of me as far as what you're accused and the possible penalties I've gone over?
No,
All right, do you intend to hire an attorney or apply for court appointed?
I don't know. I haven't talked to anybody yet.
All right, well, are you able to afford to hire an attorney?
Not, I've got one coming.
Well, do you want me to ask you questions to see if you qualify for court-appointed attorney?
Yeah, go ahead.
All right. Are you employed at this time, Mr. Everly?
Self-employed,
Self-employed? What kind of work do you do?
HVAC install.
All right. And do you have a company, or is this just something you do? Where's that located?
Fall River.
And is that where you live as well as Fall River?
Yes.
And do you have children?
Yeah, I got 5.
Okay. I'm going to appoint an attorney to represent you, Mr. Everly. Now, if you want to go out and hire an attorney, if you find a way to do that, you can. Please contact that attorney if you do not hire an attorney, and be ready to go for your next hearing. And that's going to be called a preliminary hearing control. And Missy, when will that be?
August 4th at 1:30.
August 4th at 1:30. You'll need to be back here. Now, you can appear by Zoom, but sometimes those Fall River connections are not that good. So you're always welcome to come downstairs in the courthouse and use the computer down there if you like, because it's real important that at these hearings, we be able to see and hear each other. I don't know what it is about Fall River, but sometimes they're just not the best. But you're welcome to appear by Zoom or come to the courthouse. And then we need to talk about bonds. How long have you been in the Fall River area?
40 some years.
And how long have you had the,
Same amount of time.
okay. Now, do I recall that one of your neighbors at least is one of the alleged victims?
He's the one that you got off, or sentenced to for stealing the $3,000 out of my house that he's never paid back.
All right, so one of the alleged victims broke into your house and was convicted for that?
Yes, your prosecuting attorney is the one that got him off. Or took him, got his sentence reduced.
Got his sentence reduced, okay.
Or whatever it
So,
was.
so
He
is
hasn't
that,
never paid anything anyway.
all right,
That's 3 years ago.
okay.
No restitution. Whatever you said he was supposed to do on that date that he was sentenced, nothing was ever done of what you said he was supposed to do.
Was he let off probation already?
He never had probation because of the COVID.
All right, well, that's something that a person can look into and you can talk to your attorney about, because that's not the way normally things are done, but I don't know the unique situation after it left here. I don't know. So that's a different issue though. Whatever happened in that, there are ways to follow up on that and not what's alleged here. Well, how far away does he live from you?
He lives across the street from my property now.
So if I bond you out, are you guys going to have more trouble?
No, I've got other things I've got to do.
Is he going to be taunting you or bothering you?
Your Honor, I
I
happen to
hope
know
not.
Mr. Everly has chased this child down in a vehicle, ran him off the road, made him and his friends pull over to cuss them out, chased them from Fall River to Fredonia, Kansas. He's
No, I did
taken
not.
into his own hands multiple times to the point the parents filed and considered filing for a PFA against Mr. Everly. He's trying to do back road justice against a child. And the kid is now turned 18 and he has bought his own house.
He's
They are all
21.
because Mr. Everly is his great uncle. And they end up running into each other at family gatherings until Mr. Everly throws such a tantrum that he is asked to leave family gatherings because they can't be in the same place at the same time without him screaming and yelling. Mr. Everly needs to not be seeking backyard justice, and he needs to have no contact with this victim nor his family members.
Okay, you keep talking about this child, but you told me he's 18.
He was a juvenile at the time of the crime, and now he's an adult. And so, but he's 21 years old, 20 or 21 years old. And Mr. Everly is a gentleman of more experienced age and should know better than to try to ram into people trying to put up a mailbox with a lawnmower. He's taking into his own hands justice, and he needs to stop.
Okay, so somebody under 18, broke into his house and stole, what did he say, $3,000 that they never had to pay back? And
He
now,
claims $3,000. There was restitution ordered. There was probation ordered. He ran the kid down with his friends and told him he
No, I
couldn't
did
have
not.
hang on,
kinds of problems with Mr. Everly ever since that case occurred. And Mr. Everly tries to take things into his own hands every time he sees me on the street. He comes up and starts questioning me.
Okay.
He's been a pain ever since that case happened. The child has been released because he was a juvenile at the time.
but you said he's 20 or 21 now?
Uh-huh.
So that's an old case that never did get resolution?
Old case. The kid completed probation, but you can't hold someone on probation for restitution. We all know what the case law says on that.
So the kid who's now 21 never paid any restitution for the items he stole?
I'm not going to say pay any restitution. I haven't looked it up in a long time, Judge, but
Okay,
the restitution ordered and there were costs ordered, and he had probation and he had fees he had to pay on probation.
okay. All right, and Mr. Everly, you're saying that you think that's at the root of what these charges are. It has something to do with that young man never paying you back? What I want to know, and I don't need you to answer anything incriminating, but what I need to know is if you guys live across the street, does he live with his parents or does he own his own property? Do you know, Miss Gillette? Because I thought I heard it both ways.
His parents, I thought, lived on the other side of a block, and I think he's moving into his own house or something near them. They all live in Fall River in the same area and have for years upon years upon years.
All right, so Mr. Everly, do you want to bond out?
Yeah, I've got things I need to do.
Okay, well, do you understand that if I give you a bond, I can't have you around those folks? The young man, his parents. You understand? I can't have you around them.
Yeah,
And I'm
That'll be
concerned because if what you're saying is true, you got every right to be mad if he went into your house and stole stuff and didn't pay you back. But on the other hand, you can't. It's only
he's
going to
gonna
make it
try to
worse.
put his mailbox where my driveway is supposed to be on this piece of property. That's the other problem, and nobody ever confronted me about the situation.
Well, you probably ought to be talking to a lawyer about those kind of things. You just can't take them into your own hands. As frustrated as you may be, you're only going to make it worse if you keep trying to take it into your own hands.
All right?
I mean, you've seen that. You've been sitting in the county jail. You know what I mean, right?
Yep, I know what you mean.
Did you recommend an amount, Ms. Gillette?
I have not, Judge. I would recommend 5,000 cash surety, no contact with any of these victims.
Can you do that, Mr. Everly? Can you have no contact? If they show up at the mailbox, you don't even look, you walk away. If you see them driving down the road, you look away.
Yeah,
You sure you can control
as
yourself?
long as they can stay away from me.
Well, what if they can't? You're the one on bond, not them. What if they don't?
Well, I guess I'll have to go the other direction.
Okay. They don't taunt or torment you or anything, do they?
Oh, yes, he does.
Well,
He drives around my house quite often when he does need to go by my house. All he has to do is go north right out of town, but he has the gall to go drive around me, but that's fine.
you can ignore him.
I have ignored him up until that point of the mailbox issue. I haven't talked to the kid or been around him for over a year and a half, 2 years.
Okay. All right. Well, I'm uneasy about this because I'm not sure you've calmed down yet. And I don't know if he has anything to do with it. I don't know if he totally ignores you or if he does taunt you. I don't know. But I think that there's a potential for more trouble. And if I get you out on bond, I need to know that you're not going to be a continued threat to anybody in the community and that you'll reappear for court. And I have confidence that as long as you've been in the community and run your own business, that you'll be back to court when you're supposed to.
Yeah, I'll be back.
I just don't want any more trouble with you. So I'm going to allow you to make bond in the amount of $5,000, cash or professional surety, but so only on the condition that you have no contact with this young man or are you on good terms with his parents or not?
No, his mother's one of the victims in this matter.
All right, you're to have no contact with poor. Is he the young man?
Yes.
No contact with. No contact with Joe. Is that his mother?
Yes.
No contact with. Yes.
Younger.
Younger brother. No contact with. Who is she?
Friend.
Friend. Okay.
That's his shack job.
Okay. So stay away from all of those people. If you see him going down the street, if you see him at the gas station, you're the one on bond. They're not. You understand that?
Yep.
So if they get in your face, if they give you gestures, report, call your names, report that to the police as disorderly conduct. But don't confront them, don't react, just get away because you're the one that will have your bond revoked.
Okay.
Like I said, I don't know if they do any of that, but I'm just telling you, if in the worst possible scenario it happens, that's how you need to react or you're going to be right back where you are.
Okay.
Anything else that we need to put in that bond, Miss Gillette?
No, that's it.
And Miss Gillette suggested that you've given her some grief out on the streets. Don't be doing that either. That is totally unacceptable. And in order that you have no contact with her outside the courtroom. All right. Anything further from you, sir, Mr. Mr. Everly? Yes, Mr. Everly? Anything further? All right. So make sure you get with Missy later this week to find out who your attorney is and be back here August 4th at 1:30. Are you Lydia Stubbs?
Yes, I am.
Ms. Stubbs, you're here for first appearance on a number of charges, the most serious being count 1. In that count, the state is alleging that you unlawfully possess the controlled substance. Is that Vyvanse, Ms. Gillette?
I believe so.
That is charged as a level 5 drug felony. Your sentence could be anywhere from 10 to 42 months in the Kansas Department of Corrections, commonly known as prison, and your fine could be up to $100,000. In count 2, you're accused of unlawful possession of the controlled substance butyl pills, and that is charged as a Class A non-person misdemeanor. Now, you mentioned your bond. What's your bond set at right now?
I believe it was 15,000 just from the last bit of paperwork that I received.
Okay, and Miss,
She's the co-defendant to William Connor and the roommate to Adam Ray, and all 3 of them are being evicted.
and that is the string of child pornography allegations.
Yeah, that was Mr. Ray and Mr. Connor and her had drug charges from the search warrants.
What do you have to say about bond, Ms. Gillette?
5,000 cash surety.
She doesn't have any of the pornography charges against her.
No,
Your bond will be set at $5,000, cash or surety required. Conditions include that you have absolutely no contact with the co-defendants in this case, that you have no drugs, no pornography, no alcohol, or your bond will be revoked and you can continue to wear that striped outfit in that jail.
Okay, I
Any
understand.
questions about that, Ms. Stubbs?
No, ma'am.
All right, at this time, you are excused. We are in recess on your case.
All right, thank you.
You're welcome. State of Kansas versus Melissa M. Hedges. Melissa Hedges appears in person and pro se. You are charged with count 1, speeding 78 miles per hour in a 65 mile per hour zone. This is a traffic infraction, so it does not carry jail time. There's a scheduled fine of $63. In count 2, you're accused of operating a motor vehicle with a child passenger who was not restrained in a child passenger safety system or seatbelt. This is a $60 fine as a misdemeanor, but no jail time, a $60 fine. And then court costs of $108. So if you were to be found guilty of both these charges, the total would be $223. Since you're in court today, is that an indication that you want a trial or you want time to look into diversion? How do you want to proceed?
Well, Your Honor, I was driving my boyfriend's car. It was the first time I'd ever driven it. And 1, I didn't know that the speedometer was off. And 2, his granddaughter was the one we got the ticket for. She's almost as tall as I am. And she's literally the same height as her older brother. And he was also with us, and we didn't get a ticket for him, but we did for her. So we didn't know that she had to have a car seat because her mom didn't give us one. So I mean, she's almost as tall as I am. So I don't understand how she needs a car seat when she's almost as tall as I am.
Well, do you want to set the matter for trial then? I will accept the defendant's no contest plea and the state's factual basis to support that plea, finding the defendant guilty